Hello, everybody. I'm Seth Weissman, and welcome to another episode of Safe Real Estate. Today, I'd like to talk about the situation where someone loans the buyer the earnest money. And this is not all that infrequent an event. Usually, it's a relative that loans the buyer the money, but it raises questions as to what happens if the buyer then defaults and the earnest money is lost. Does the person who loaned the money to the buyer have any recourse to try to get the money back? And the answer is no. That person may have a claim against the buyer, but they do not have a claim to simply get the money back and put it in their pocket. So if the transaction moves forward and there's a closing, the earnest money is used to help pay for the property. If the transaction goes awry and the buyer defaults, that earnest money goes to the seller. It's clearly a situation where the money is not so much a loan, but the money instead is treated by the broker as a gift. If the transaction does not occur at all, the broker does not give the money back to the person who loaned it. The broker gives the money back to the buyer. But it is critically important that when this scenario arises, that the broker get a form signed in which the person loaning the money acknowledges that they have no rights or recourse to that money once it is paid to the buyer. And GAR has created a form, F525, that accomplishes just that. It clearly states that when the money is given on behalf of the buyer, it becomes the buyer's money, and the broker treats it as if the money was deposited by the buyer and not by the person lending the money to the buyer. So, what you always want to do when the money is being deposited by a third party is you always want to get that F525 signed. I hope this episode of Safe Real Estate has been beneficial. As always, it's great to see everybody. Please continue to tune in. Bye now.